Here.
Uh-oh. Oh, ma'am, you got to be kidding me.
What's wrong?
What's wrong other than that we just saw your entire mid section?
Judgment's wrong, in and out, the verdict's wrong. Oouchie Court watch, we've just begun. Oouchie Court watch, we're on the scene. Truth's unraveling, what does it mean?
Mr. Oouchie, I don't know what's wrong with your client's device, but it's not. It looks like it's stuck. It's saying joining, but it's not joining. So it looks like it's, I don't know if he's not at his device or something. Maybe you can
I'm at
call
my
him.
device. I don't know what's going on.
Sir, I really am not speaking to you. So please stay muted. Thank you so much. We're in court. It's like a lot of people here. Okay, so Mr. Oouchie, maybe you want to call your client. All right, this is case number 234498101. The people of the state of Michigan versus Deshae Unique Bryant. Defendant is charged with operating while intoxicated with the occupant under the age of 16. And today is the adjourned date set for review. And there was a request for a show cause that I don't know that I signed. Appearance, please.
For the record, Your Honor, Janice Stevenson appearing on behalf of Deshae Bryant. Ms. Bryant, ma'am, please say your first, middle, and last names.
Deshae Unique Bryant.
All right. So yesterday was the date set for review, and then I saw the report, and so I had Ms. Bryant come in to be tested, and thankfully, she tested negative yesterday, but she has tested positive on November 27th, and she missed December 27th. Those are both unacceptable. That's unacceptable. Unacceptable. Not acceptable. Okay, Ms. Stevenson.
So, Your Honor, with that condition of testing, I think the only other issue of compliance with which Ms. Bryant had demonstrated was payment of $200. I believe now she has a zero balance. Ms. Bryant doesn't, we've already talked about the fact that a missed test is considered a positive test. So she's looking at 2 positives right now. I shared the court's delight that she tested negative yesterday, that she came down and tested on the spot and she tested negative. I expect her to continue to test negative.
I expect it too, because otherwise it's not going to turn out good for her.
Ms. Bryant definitely
sobriety court.
She understands that, and she's not eligible for an early discharge, I believe, until next month sometime, Your Honor. So if we could just get this testing taken care of and make sure she continues to test negative, I think she's going to demonstrate that she's been a great probationer. So I would ask the court to set review for sometime in the month of February.
She missed the test and she tested positive. I'm not giving her in February.
Okay.
No.
At some point, Your Honor, still past the halfway point, but before the final review date, we would be asking for adjournment, and asking, it's like the only thing left to do is to continue to test and test negative.
All right, I'll give her a 1-year date. I'll give her a May date, but I'm not giving her. So instead of violating her, which she has violated. So instead of violating Ms. Bryant, I will still give her an opportunity to be discharged early, but not at the original halfway point. She can be discharged if she does not miss another test and if she does not have any positive tests. Any positive test is going to result in a violation and a referral to sobriety court. Any positive test and any missed test. Is she testing off-site or at the court?
She's testing off-site, Your Honor. There was, I would leave it up to Ms. Bryant as to whether she wants to continue to test off-site or if she wants to come to the 36th District Court. That December test, the miss was a little bit strange, in that she arrived. So she got to, Ms. Bryant explained to me that she got to the testing location and she was close to the closing time. That she was not permitted to test because of, I don't know if they had closed or they were about to close or what, but then they gave her a form and told her to sign it, and that the form indicated that she was refusing to test. So we talked about not signing anything that wasn't factual. She said that the other option they gave her, if she don't want to sign that, is that she could come in and test the next day. She already knew, based upon what you told her before, that, you know, going in and testing after the random test date was, you know, was a waste of her money. So she didn't want to do that. But I don't know, I would just leave it to Ms. Bryant as to whether she wants to continue to test there or start coming into the courthouse for testing because of that experience.
Okay, well, I mean, I can't imagine signing something that says I refuse to test and thinking that that was going to sit better with the judge than I tried to test the next day. So let's just, if she wants to start testing at the court, she needs to go across the hall and speak to her probation officer and let them change her. She could test at the court, but then I'll have to add the fee because I must, did I add your analysis fees already on her, Mr. Flanagan?
Yes, Your Honor, $360.
So that also means we need to put a note that if she's been testing off-site, she shouldn't be paying the urinalysis fee for us. So send a note to her probation officer. I need to know, we need to back out some of those fees. And then if she starts testing at the court, then, you know, we'll just back out the one where she has tested somewhere else. We can't double charge her.
All right.
So let's send a note to her probation officer about that. And so if you want to test, then see Mr. Hunter. If you want to test at the court, then set that up with Mr. Hunter. If not, continue to test off site, but we need to make sure we back those fees out. And I'm gonna continue you to May. I'll put her on May 1st, the first day of May, but that's the earliest I'm gonna give it. So she needs to test February, March, and April. Cannot have any missed or positive test. So don't go, if you continue to test off site, don't go at the last minute. All right, anything further, Ms. Stevenson?
Nothing at this time. Thank you very much, Your Honor.
All right, then we're all set. Have a great day. Stay safe.
Thank you, Your Honor.
You're welcome. This is case number 204552501, the People versus David. Mark DeLucia, defendant, is charged with operating while intoxicated. Today is the date set for review. Ms. Stevenson.
For the record, Your Honor, Janice Stevenson appearing on behalf of Mr. David DeLucia. Mr. DeLucia, sir, please say your first, middle, and last names.
Unmute, sir. Unmute.
Okay. David Mark DeLucia.
All right. Today is the day set for review. Mr. DeLucia, you've done a great job. However, you still have 94 hours of community service and $210. Ms. Stevenson.
So, Your Honor, with regard to the $210, I would ask the court to consider
That's not
suspending.
mandatory costs. Those are mandatory costs. I'm not suspending it.
So, I understand, Your Honor. Mr. DeLucia was in the Michigan Department of Corrections from. Mr.
But I
DeLucia,
already knew that when I did that because I have on here that he has to remain in compliance with his parole.
right, and so I don't know that. So the court did convert costs and fines over to community service. I think that's where the 94 hours comes from. But then it's also the court did assess the $210. And I would ask the court to give him credit for the time that he spent in the Michigan Department of Corrections while this warrant for his arrest was outstanding, while this matter remained unadjudicated. So that's for the 210. Understood, Your Honor. With regard to the community service, Mr. DeLucia, I'm going to have to do something I don't normally do, and I'm going to ask Mr. DeLucia to explain to this court his request with regard to the community service that we talked about in the breakout room.
Let me ask you this question that has nothing to do with Mr. DeLucia.
Yes, Judge.
You talked to Ms. Poor in the dark?
I did not, Your Honor.
Okay. Okay. I'm going to put Ms. Poor in the waiting room for a minute. All right, Mr. DeLucia.
Hi, Judge. It's good to see you again.
Good to see you.
I'm doing fantastic. First of all, I just want to show you a few things that I'm really proud of. Here's all my coins I got from my AA group, all the months, and I just got my 1-year coin on the 2nd of January.
Awesome. Uh-oh, look, he getting ready to change my mind, Mr. Stevenson. Whatever. Go ahead, Mr. DeLucia.
Do your work, Mr. DeLucia.
Hey, look out the window. Look what else I got. Can you see that?
I can.
So I got my license back and I got a new car. As far as the community service, I was wondering, I talked about it with one of my counselors, if I could go to it's a recovery coach academy. It's 50 hours of online training, and they teach you how to be a peer recovery coach. They teach multiple pathways: smart recovery, celebrate recovery, well-briety, recovery dharma. Yes, and if I could go and do that class online and do some volunteer work at Harbor Hall, where I go to my outpatient, could that satisfy my community service?
Yes.
Okay.
Yes.
Cool.
Absolutely.
Oh, by the way,
I'm going to change my mind about the 210. You see how
hey,
I'm just a big I'm one of those irritating little dogs that be barking and they can't do nothing.
See, look at my shirt.
Your shirt. Yes. Mr. DeLucia, let me first say, you should be proud of yourself, but I'm proud of you also. And congratulations on your steps in sobriety. Congratulations on the work that you're doing outside of the Michigan Department of Corrections. Just congratulations. So the answers to your questions are yes. Yes, I changed my mind about the 210. See how unmandatory the costs all of a sudden became. They are mandatory costs, but in some situations I can waive them, and I'm going to waive them based on what you just told me. It sounded more convincing when you showed me your coin. So
see,
I didn't listen to Ms. Stevenson. She begs me every day. So
the miracles just keep happening.
They do, and keep on. See, and also because it took me a minute to learn that your words do have power. I mean, they said that to me, all the time I was growing up, and I didn't get it. It took me a minute to learn it. And it also took me a minute to learn that your attitude towards something, it just does draw, more positive things to you. And that's why some people, we see some people, seems like they continue to get good things because their attitude is good, even in the face of bad. So just keep going, Mr. DeLucia. You're doing a great job.
I just want you to know it took me a lot of work to get where I'm at today.
Yeah,
I suffered 59 years, and I still made it. By the grace of God, I'm still alive and have a chance to do this. I got my family back in my life. I mean, everything is really just going good for me.
And that's good.
Congratulations on your YouTube fame. I see.
Oh
you
my,
on
Mr.
YouTube.
DeLucia, don't bring that YouTube stuff up
Hey.
here on here.
Hey,
I
saw
wish
you
it was,
talking
Mr.
I saw you
DeLucia,
yeah.
I wish it was congratulations to me. You need to congratulate the people who making money on our backs because they
Oh,
not
yeah.
sending us any check.
I saw you putting that sovereign citizen in their place.
Uh-oh. Look,
Just
He was
don't show
doing
up.
good. He was doing good, Miss Stevenson.
I thought it was funny.
Mr. DeLucia, but you keep up the good work. You keep up the good work. Again, congratulations on your sobriety. Congratulations on how you're approaching life positively outside of the Michigan Department of Corrections. That's phenomenal. Again, I don't know if I quoted Brian Stevenson to you previously, but you know, an attorney that I respect and honor. I don't know him personally. That you know, I read his book, saw the movie about him, but one of the things that I grabbed a hold to from him, and he does work with prisoners that are on death row. So these people are on death row. And one of the things that he says up to them and about them is that we are all better than the worst thing we've ever done. So the worst thing I've ever done, I'm better than that. I can come back from that. No matter what it is, I'm still a human being. I still have an opportunity for growth, for learning, and for change. So you're doing a phenomenal job. I am going to waive your $210 and will allow you to do that course. Ms. Stevenson, let's get the name of it so Mr. Flanagan can put it officially in the record.
Yes, sure.
It's called upicrecovery.org.
Okay.
And it's the Recovery Coach Academy through NMSAS, NMSAS.
Mr. Flanagan, did you get all that?
upicrecovery.org.
Yeah,
that's what I got. I didn't get the rest of it.
That's the website. It has everything on there.
It's a recovery coach, and then he gave you some initials, and he said that's on the website. We can look it up. So yes. So how long is that course though?
I think it's over 2 months.
Okay.
It said it's 40 to 50 hours, so I'm imagining it's a couple hours at a time.
All right. So
I just found out about it a couple of days ago. My resource manager suggested it to me because I actually wanted to go back to work at a treatment center, Bear River, where I graduated from last year, and they want me to come back in some capacity, maybe doing transportation, but peer recovery coaches don't make anything, but it's just valuable to my for my recovery to give back to the community that helped me.
I agree. So let me ask you this, Ms. Stevenson, then what kind of, he says the course is like 2 months. So do we want to come back in 3 months? And then, because the final discharge is June, but we could come back, let me see. This is January, February, March. We could come back end of March or April. Or do you want to just continue to June?
I think I want to continue to June so that Mr. DeLucia can just bring whatever certification or commendations or anything else he's gotten to show to the court.
All right,
can do that.
Let's continue to June 6th. Oh, okay. wait. No, June 6th, that's not gonna be a good day. Hold on, I gotta change. Because that's gonna be, I'm not gonna be here. Okay, June 6th is not a good day. Let's do him June 5th. Let's do June 5th. So just move it forward one day, Mr. Flanagan, June 5th.
Yes, Your Honor.
All right, keep up the great work, Mr. DeLucia. Keep up the great work, and I look forward to seeing you in June, okay?
Thank you so much, Judge.
All right, you're welcome, and stay off YouTube, Mr. DeLucia. It's not good for you.
I got to see
stay
if you're
off
back
YouTube and TikTok and all of that.
I don't go on TikTok. I just watch YouTube.
All right.
All right.
Thank you, Your Honor.
You're welcome. I'm ready on green. All right.
Here.
Uh-oh. Oh, ma'am, you gotta be kidding me.
What's wrong?
What's wrong other than that we just saw your entire mid section? You say
Where?
what's wrong? Ma'am, don't do that. Don't do that. Okay. I wouldn't make it up. Your shirt was just above your belly.
Oh, because it keeps rolling.
Ma'am, we're in court. And if your shirt I'm not going to do this. Not in 2025. Okay. Okay. Not in 2025. You can let her know what date she's going to come in person. All
this
right.
week, Your Honor.
I'm sorry.
This week.
Yeah. So, yeah, okay. Somebody has her phone number because I'm not even bringing her back in here. You find out what day she's going to come in person. Okay. All right. This is case number 194451001. The people of the state of Michigan versus Adriana Bianca Green. The defendant is charged with 1 count of malicious destruction of property, 1 count of assault or assault and battery. Today is the date set for a pretrial conference. Appearances, please.
Good morning, Your Honor. Dawn McLeod on behalf of the people.
For the record, Your Honor, Janice Stevenson appearing on behalf of Adriana Green. Ms. Green, ma'am, please say your first, middle, and last names.
Adriana Bianca Green.
Ms. Stevenson, how are you proceeding?
Your Honor, we would move for dismissal for the complainant's failure to appear.
Ms. McLeod?
Your Honor, I contacted the complainant, Dwayne Adams, yesterday and spoke with him. He said that he does not recall the June 18th incident, and he also no longer resides in the state of Michigan, and therefore the people are unable to proceed with this matter.
All right, today's the day set for pretrial conference. The complaining witness lacks recollection sufficient for the people to proceed. So, Ms. Stevenson, you could put the reason as insufficient evidence on the dismissal.
Okay, Your Honor,
Yes.
on the motion that I tender, I don't think there.
Oh, you have the other one.
Yes, Your Honor.
Okay, no worries.
Okay.
All right, then the court is going to dismiss the matter, not because the witness failed to appear, but because the witness indicates that they do not recall the matter and live out of state, and the people are unable to proceed. And so, Ms. Green, you can have a seat at the direction of the officer. Mr. Flanagan will scan that order to me and I will sign it, and we can give her a copy of it before she leaves the court.
Thank you, Your Honor. Your Honor, Ms. Green, if it please the court, would like to address the court.
All right.
Judge, I apologize. I really do. I was sitting there waiting to proceed, and I'm sorry. I changed my clothes. I fixed myself. I'm so sorry. I didn't mean to upset you or do anything wrong. I really apologize. I'm not a bad person at all. And I hope you accept my apology. And I'm sorry again. I really am. I apologize.
And I do accept your apology. And I didn't think you were a bad person. I just concluded that your appearance on Zoom was not appropriate. So I accept your apology. I never thought you were a bad person, and I appreciate your apology. And so thank you very much, Ms. Green.
Thank you. I hope I don't have to see you again.
Me too. Well, on the street, maybe. Like, you are right. You could just, and then don't walk up to me and say, you remember me, you was my judge, and you don't.
I ain't even gonna do that. I'm just gonna say, do I look okay today?
And Miss Green, if you do that, I will remember exactly who you are. Okay? You have a great day. I'm gonna sign your order and we'll get you a copy. Okay? Thank you, Miss Green.
Yes, ma'am. Enjoy the rest of your day.
All right, you too.
Watch, we're on the scene. Truths unravel, and what does it mean? In the halls where stories clash, Oouchie court watch quick as a flash.